In this session, I will be briefly discussing the principles of natural justice. Today, the concept of natural justice and its application to administrative functioning has acquired universal recognition, and it has become a part of administrative law. Natural justice is the essence of fair adjudication, deeply rooted in tradition and conscience, and ranked as fundamental. The purpose of following the principle of natural justice is prevention of miscarriage of justice. The objectives of the present session is to understand the concept of natural justice, describe the principles of natural justice, and highlight the applicability of principles of natural justice to the administrative actions. Let us first see what is meant by the term natural justice. The meaning and scope of the term natural justice is not fixed. Different judges and philosophers have defined it differently. Natural justice is derived from the word jus, naturally, of the Roman law, which means principle of natural justice, equity and good conscience. These principles did not originate from any divine power, but are the outcome of necessity of judicial thinking as well as the necessity to evolve the norms of fair play, and it is closely related to common law and moral principles. These are basically procedural principles which every administrative agency must follow while taking any decision which adversely affects the rights and liberties of private individual. The rules of natural justice do not supplant the law of the land, but only supplement it. These are firmly grounded in Article 14, 19 and 21 of the Constitution. The rules of natural justice are not embodied or codified rules. What particular rule of natural justice should apply to a given case must depend to a great extent on the facts and circumstances of the case, the framework of the law under which the inquiry is held. Now, let us see when natural justice is invoked. Earlier, it was said that these rules applied only in case of acts regarded as judicial or quasi-judicial. A distinction was made whereby rules did not apply where executive or administrative function was involved. Now, for application of rules of natural justice, the characterization of the nature of action as judicial, quasi-judicial or administrative has no role to play. It is the consequences of the action which matter. In case where the administrative action is likely to prejudicially affect the civil rights and liberties of the individual, then without any distinction the natural justice will apply. Now, let us see what are the principles of natural justice which we are talking about. Traditionally, natural justice comprises of two rules. The first one, nemo judex in causa sua, or rule against bias, which means no man shall be judged in his own cause. The second one, audi alterum partem, or the rule of fair hearing, which means hear the other side or no one should be condemned unheard. But the concept of natural justice has undergone a great deal of change, and the courts have recognized a third rule that says reasons should be given for any decision which is taken, which is also known as speaking order. Let us now examine what the first rule, that is rule against bias, means. Bias means an operative prejudice, whether conscious or unconscious, in relation to any party or issue. The judge may have strong views or preconceived ideas concerning the case before him, which tends to cause such a person to decide the case otherwise than on evidence. The principle is basically based on two rules, that is, no one should be a judge in his own case. Justice should not only be done, but manifestly and undoubtedly be seen to be done. The essence is that the rule applies impartiality in the decision maker. Such impartiality must manifest itself in the conduct of decision maker during the proceedings before him. The bias which vitiates the action of an administrator can be of any of the three kinds. The first one, the pecuniary bias, when the adjudicator or the judge has monetary and economic interest in the subject matter of the dispute. The second kind can be personal bias, that arises when there is a personal equation like friendship, relationship, business or professional association or animosity with any of the parties. The third kind of bias that prevails is bias as to the subject matter. When the administrator or the judge has a general interest in the subject matter in the dispute on account of his association with the administration, and the adjudicator has intimately identified himself with the issue in dispute. In order to challenge administrative action successfully on ground of bias, it is essential to prove that there is a real likelihood of bias. It is not possible for the court to find out the state of mind of the person. So, the test of bias applied by courts is of real likelihood of bias. That means, whether a reasonable man in possession of the relevant information would have thought that the bias was likely to affect the decision in the given case. The doctrine of necessity creates an exception to the rule against bias, which means there are certain extreme cases in which substitution, replacement of impartial adjudicator is not possible. In such situation, the principle of natural justice under necessity has to give way. The second fundamental principle of natural justice is audi alteram partem, or rule of fair hearing. It means no one shall be condemned unheard. That is, there must be fairness on the part of deciding authority. According to this principle, reasonable opportunity must be given to the person before taking an action against him. This is the second long arm of natural justice, protecting the little man from arbitrary administrative actions which is going to have civil consequences. Right to fair hearing is a code of procedure and hence covers every stage through which administrative decision making passes. To constitute fair hearing, notice is the first limb. It is necessary to provide an opportunity to the person so that he can equip himself to defend his case. Notice must be reasonable and unambiguous, containing time, place, charges, nature of hearing and other particulars. A defective notice vitiates all subsequent proceedings. Person should be given an opportunity to submit his explanation to the charges as well. Further, the rule requires that during the course of hearing, all evidential material, both oral and documentary, by which the matter is proposed to be decided must be disclosed. All evidences against the party must be gathered in presence of the party and there should not be any evidence at his back. The party has also right to cross-examine the witnesses and to lead his own evidence, both oral and documentary, in his defense. It is basically a code of procedure which has no definite content but varies with the facts and circumstances of each case. The concept of post-decisional hearing is now gradually getting recognized to satisfy the requirements of audi alteram partem rule. However, it must not be taken as a general rule. Resort to post-decisional hearing can only be justified where prior hearing would frustrate the very object of the administrative action. The post-decisional hearing must be remedial in nature with full and fair hearing and must be conducted by the same authority which earlier took administrative action or considered the matter. The third principle of natural justice which is being recognized by judiciary now is reasoned decision or speaking order. A reasoned decision is an intelligible order, an order which speaks its own story. The requirement of reasons is an effective check on the arbitrary exercise of power. The desirability of such requirement becomes more pertinent in our country as the legislature here seldom incorporates a provision requiring giving of reasons in the law. It provides a considerable assurance that the decision will be better as a result of being properly considered by the authority. The giving of reasons enables the party to plan for appeal, revision and make a tribunal more amenable to the supervisory jurisdiction of the courts. Where the reasons for the decisions are not given to the person concerned or reasons are not given to the court, the order is quashed and the authority is directed by the court to examine the matter afresh. Now, let us see what will happen if the principle of natural justice are not followed. When the authority is required to observe the principles of natural justice in passing the order, but fails to do so, the general judicial opinion is that the order is void. In England, in the case of Ridge versus Baldwin, the court held the decision of the authority void on ground of breach of the rule of fair hearing. In India, the position is well settled that the order passed in violation of principles of natural justice are void ab initio. However, the courts have recognized that there are certain conditions in which the principles of natural justice do not apply. These principles do not operate in the area where they are statutorily excluded, whether expressly or by necessary implications. In case of extreme emergency, where the interest of the public would be jeopardized by the delay or publicity involved in a hearing, then the principles do not apply. In case where the prompt preventive actions are needed or it is impracticable to hold hearing, the rules have been excluded. Exclusion is also there in case of purely administrative matters or where the no rights of the person is infringed, and sometimes non-observance of the procedure would not make any difference to the outcome. In such cases, the court does not interfere with the decisions for the violation of natural justice. So friends, in this session, I have tried to provide a synoptic overview of principles of natural justice. With this, I end my session and leave you with some questions which I hope you will be able to answer easily now. Thank you all.